Welcome everybody to D&B's 5-minute briefings. I'm Neil Isherwood, an SME and strategy leader in our third-party risk and compliance line of business. And today we're going to look at the subject of UBO accuracy and discrepancies. There's actually been quite a lot of movement recently in this area. We have the AML packages proposed in the EU. We had the decision by the EU Court of Justice that declared public access to UBO registers was invalid. We've had the Economic Crime, Transparency and Enforcement Act in 2022, followed quickly by the 2023 Economic Crime and Corporate Transparency Act. And beneficial ownership is a key piece that cuts across all these areas and regulations. Now, focusing on the Economic Crime and Corporate Transparency Act, this gained royal assent in October 2023 and will result in huge changes to the registrar of companies. Companies House has faced criticism for a number of years around the quality of the data held. However, it was never actually given any real powers to do anything about this. It is under an obligation to reflect any correctly filed information, and note that this means they just check that the forms are filled out and filed correctly, and they don't actually check the content on the forms is true. For example, the company directors, which could be fictitious. And there have been numerous examples showing that this has been exploited, where networks of shell companies, fake directors, and fake UBOs have been uncovered. This new act will require identity verification for people filing information with the registrar, as well as the directors and PSCs of companies, therefore removing the ability for anonymity. As such, the reforms will transform Companies House from being a passive administrator of information to being an active gatekeeper and ensuring accurate and reliable information is on the register. From a European perspective, there is a lot going on. The trilogues are underway, negotiating the final points of the proposed AML regulations and directives, and also deciding where the new AML authority, or AMLA, will be physically located. A criticism of the previous anti-money laundering directives was that member states were slow to implement them and also chose differing methods, each with variable efficacy. An example of this was the slow progress in introducing beneficial ownership registers, mandated as part of the 4th and 5th directives, with some member states even being referred to the European Court. Also, the new AML authority will also assume direct supervisory responsibility for large European financial institutions, a change that was introduced as national regulators came under fire in a number of money laundering scandals. And finally, as mentioned, we still have the fallout from the EU Court of Justice ruling, which declared that public access to these registers was invalid. And this is a key point that's being deliberated over in the trilogues as to how this should be handled, with the emphasis moving to legitimate interest, a term that has been a struggle to thoroughly define and nail down, as well as the scope of parties that are deemed to have it. So, in summary, a lot is going on. So, with all this in mind, we decided to try to take a pulse check on the accuracy of UBO information. This is obviously a tricky task to truly understand, as clearly no one has the ability to fully investigate every single registered company. So we have used the information gathered through the requirement for obliged entities to report any discrepancies they have seen on the client information they hold on UBOs versus the details on the public registers. So we placed a Freedom of Information request to Companies House to obtain the monthly volumes of these reports. You can see here in the center portion of the graph, the discrepancies reported ramped up to approximately 5,300 per month across all UK obliged entities from January 2021 to June 2022. But to put this into perspective, the UK register size is over 5 million companies. Then in June 2022, the money laundering regulations were amended and the section covering the reporting of discrepancies was changed to only require material discrepancies. And anecdotally, we had heard of some institutions taking an approach that did a character for character comparison of their records compared to the register. So very minor differences in formatting could have been reported with this approach. Subsequent to this change, we can see a drop in the discrepancies being reported to approximately 3,350 per month. So that's roughly a 37% drop from that previous part of the graph. One thing we have noticed when comparing different sources of ownership, such as the confirmation statements and the PSC filings, is that it does appear that some of these can just be genuine misunderstandings of the obligation, because we must remember that there are many micro and small businesses where the details and nuance of the definitions, etc., are quite vague concepts. So it doesn't always entail financial crime being behind these. So there we have it. I hope that gives some indication in terms of perceived accuracy of information. And we shall have to wait with bated breath to see how the Companies House reforms and the EU AML packages progress and the subsequent impact on availability and quality of UBO data going forward. So thanks for listening, and if you have any questions in these areas, please contact us using the details on screen.